Mr. Brown, I'm just going to ask that you appear as the duty attorney for this arraignment.
Sure.
So, Mr. Moore, what that means is that if at any point during this hearing, it looks like Mr. Brown was your attorney on the underlying case. If at any point you have any questions or you want to talk to him about what's going on, he's available here, and I would allow you to do that. Okay.
Okay. Thank you.
For the record, this is People versus Chad Moore, file number 216157. Mr. Moore is present here in the courtroom today. And he is here. Mr. Moore, you're here for show cause hearing for probation. And that alleges that you have not made any payments towards your fines and costs on this case. Do you understand why you're before the court today?
I do, Your Honor.
Okay. And so I'm going to go through a few things with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you should be found to be in violation of your probation. You also have the right to have a lawyer present at any subsequent proceedings. If you can't afford one would be appointed for you. As I've indicated, Mr. Brown is present here today. If you had any questions. If you are found guilty of violating your probation, it could subject you to the maximum possible penalty on your underlying charge, which is third offense OWI, and that's 5 years. Do you understand that?
Yes, Your Honor.
Okay. Mr. DeLeo, has Ms. Davis indicated how she wants to proceed ultimately with this case? Or does she have any notes for today's hearing?
Well, I think the focus, Your Honor, obviously is getting Mr. Moore to pay. I know he's coming up on his 5-year term of probation. I'm not sure exactly how close he is to his discharge date, but he's getting close. So I think the recommendation would be to, adjourn it out a little bit to at least see if he'll make some efforts to pay, and I think obviously on what he does, ultimately make a recommendation at that time.
Okay. So, Mr. Moore, what I would do for today's purposes is enter a not guilty plea on your behalf, and then have you communicate with your agent, Ms. Davis, to see how this could be worked out. But do you want to request a court-appointed attorney to represent you, or did you want to hire your own attorney?
Well, I don't have the money to hire my own attorney. So I would just pay the fines. I'm not trying to be smart.
No, I get it. I understand. I'm just required to ask you that because of your rights. So what I'm going to do, Mr. Brown, is refer Mr. Moore's case to your office for screening for eligibility and appointment of an attorney if he's eligible.
Thank you.
So communicate with Mr. Brown. They have a process where they screen you financially, and he'll appoint an attorney for you if you qualify. And if it sounds like you probably will qualify and did before. So make sure that you stay in touch with Mr. Brown.
I definitely will.
Okay. And we'll enter a not guilty plea on your behalf. Mr. DeLeo, is there any objection to a PR bond in this case?
There's not.
Okay. So the court's going to set this as a personal recognizance bond, so you don't have to post any money on Mr. Moore, but you do have to continue to comply with all the terms and conditions of your probation. Okay.
Correct.
So 2 things. Number 1, you need to communicate with Ms. Davis, with your agent. And then number 2, make sure you stay in touch with Mr. Brown. I'm going to set this for a hearing about 90 days out. If Ms. Davis wants to have that hearing earlier, she can just contact the court and get a hearing date. But we'll set it for 90 days out, and then you'll get notice of the date and time of that hearing, just like you did.
Hopefully by then I can have them paid.
Yeah.
So,
I think that would be great for all of us. Yeah.
I realize that, Your Honor.
Okay. All right. Do you have any questions, Mr. Moore?
I do not.
Okay. Thank you. That's all for today.
All right. Thank you, Your Honor.
People versus Jared Miller, file number 256837. Is Mr. Miller present? Can you come up to the podium, please?
For the record, Chairman, all that people, they're on campus.
Mr. Miller, how did we want to, or I'm sorry, Mr. Brown, how did we want to proceed with Mr. Miller's case?
Your Honor, I have had some difficulty contacting Mr. Miller. He did reach out to me yesterday, Sunday, via text, so I was able to finally connect with him. At this time, I believe we are going to proceed to the trial, which is set later this month. Just for the record, there has been a plea offer in the matter that he could plead to the same charge, different amounts, which would be a misdemeanor if at or before sentencing, he would pay the full restitution. That he is made aware of that, but we are going to proceed notwithstanding.
Okay, Mr. Miller, have you had a chance to talk to Mr. Brown about that plea agreement?
Yeah.
Okay. And you're aware that today would be the last day that you could enter into any type of plea agreement?
Oh, no, I didn't know that. I just can't see taking a plea for something I didn't do. I mean, I have no problem paying the money back for doing the roof. So I just, I can't make contact with the homeowner to work that out at all. So I just don't know. I'm here, but I'm not going to plead guilty to something I'm not guilty of.
Okay, so we're going to proceed then with your trial on July 31st. So you need to be here by 8:30 on the morning of trial. I'm going to suggest to you that you should get in touch with your attorney because he's going to be representing you at that trial. And in order to effectively do that, he needs to.
Yeah, my phone went inactive and I won't have it on until after court days. But yeah, somebody should be.
Well, it's a pretty serious matter. You're being charged with a 5-year felony here. So whatever you need to do to communicate with him, I just want to make sure that you're clear that, you know, any kind of lack of communication or you change your mind, nothing's going to stop us from going forward July 31st. So I'm just be prepared to go forward on that day. Mr. Rolla, are the people ready to proceed?
Yes, Judge, in accordance to information, the parties have already exchanged pre-trial documentation, witness list, exhibit list, and jury instructions. Copies should have already been provided to the court. Well, thank you, Judge.
Great. Mr. Brown, any other matters we need to discuss today?
No, Your Honor, thank you.
Okay. So, Mr. Miller, again, we'll see you at 8:30 on the morning of July 31st. Thank you.
Okay, thank you.
Time to break this one down. We had not one but two back-to-back hearings here, both under the same roof, and while neither case featured any courtroom fireworks, there was still plenty to take in. Judge George Mertz once again handled things with steady professionalism, keeping everything grounded and making sure every party had their say. The first matter involved Chad Moore, who was up for a probation violation, specifically for failing to make any payments toward his fines and costs. It's one of those situations where the judge isn't aiming to drop the hammer, but does need to move the ball forward. The court appointed Mr. Brown to appear as standing counsel for the hearing, giving Mr. Moore some support while they figured out next steps. Judge Mertz made sure Moore understood the situation and the possible consequences, including a 5-year cap if things go badly, but also made it clear this wasn't about punishment today. Instead, the goal was to get some progress on those payments. The state's angle, via Mr. Dalio, was practical. Give Moore some more time, see if he makes an effort, and then revisit. The judge entered a not guilty plea on Moore's behalf, referred him to the public defender's office for screening, and scheduled a hearing 90 days out. All fair, all by the book, and Mr. Moore, to his credit, was polite, cooperative, and expressed understanding. He even added, not trying to be smart, when clarifying he couldn't afford an attorney, which was a nice moment of humility. The vibe here? Calm and procedural? Everyone doing their jobs. Then we moved on to Jared Miller. This one had a little more tension, not dramatic, but you could feel some friction under the surface. Miller is facing a 5-year felony and had the option of a plea deal, which would have let him plead to a misdemeanor if he paid full restitution. The catch: that deal expired the day of the hearing. Miller said he wasn't aware it was the deadline, and expressed that he couldn't accept a plea for something he says he didn't do. You could tell he wasn't defiant, just a little cornered. He even said he's fine paying back the money but hasn't been able to contact the homeowner. Judge Mertz made it crystal clear that trial is moving forward on July 31st, plea deal. Or no moral lectures, no raised voices, just a strong nudge to Miller that this is serious business and he needs to stay in close contact with his attorney. Mr. Brown noted some past trouble reaching Miller, but they had connected the day before via text, so communication may be on the upswing. The court's tone was still respectful, but you got the sense that patience is wearing a little thin here. Everyone just wants the matter resolved, and Judge Mertz isn't going to let any tech issues or vague, "I couldn't get in touch" excuses derail that. So, two different defendants, two very different situations, but one constant, a courtroom run with clarity, fairness, and just enough wiggle room to let folks get their act together. The judge wasn't there to scold or shame, he just wants to keep things moving. And as hearings go, this one had all the ingredients of good courtroom practice without the drama. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.